I know this is not the most popular subject with the legal profession because part of it is going to lead to reduced costs for the public, and I think I start off with the concept that the present day system of judges and adversarial lawyers dealing with, other than criminal matters, dealing with people chasing money, seeking rights to be enforced, seeking injunctions and everything else, is beyond the ability of people to use the services. I have a number of my clients who over the years, love me though they may do, they now will not go to court. They simply say that they cannot afford to go to court to enforce payment of rent, to chase people who've owed them money for some other reason, to enforce their rights. There's got to be some other way. And that is repeated to me over and over. I came from a one-man practice. Over the years, I was the original managing partner for a firm which used to be called Bryden and Doherty with Henshaw, Woke and Forrester, and it became Bryden's at my suggestion because it was number one in the phone book to a certain extent. So different reasons you do things. I'm now, even though I have a practice at Wollongong, that is really only a pro bono practice for people who come from the cathedral for wills and what have you, and I enjoy it in my semi-retirement. I'm a partner still, well, not a partner, but a one-day-a-week lawyer in Marsden's, which is probably the biggest firm outside Sydney law firms, and it deals with a lot of people. It has nothing to do with my submission. I didn't tell them what I was doing, and that's not what it's about. But I'm putting to the Law Society and I'm putting to the public that we are beyond having a system at the moment which can handle the average court requirements, justice requirements of people seeking compensation or anything else in the civil court jurisdiction. It's run by judges, it's got solicitors and barristers in an adversarial position. Anyone who's been to court will know what that's about. What I'm proposing that instead all questions of fact and all civil claims be determined in the main by not by adversarial but by inquisitorial. Judges, call them what you will, I call them referees, that they be judicial referees, that they be mainly lawyers. I mean, it might provide the other side of the job for the lawyers, but they should have legal qualifications, certainly a good knowledge of the law, to be dealing with the matters that come before them. That first of all, that they go to the registrar to issue their process, that before it gets anywhere, it goes before a mediator. That a mediator deals with the issue of can it be settled. Even the most beyond mediation, that it just goes to the issue, can we get this settled? This is what it's going to cost you. The whole lot is put before the parties before they get anywhere near the court. Finally, when that's determined and when the mediator has an idea of what sort of processes are going to be involved, what sort of facts are going to be involved, it would then be sent to be dealt with by a judicial referee. And that would be set down when the person who's making the claim or wants the matter heard pays into the court a fee which covers the cost of the mediator, of the judicial referee, that it pays the cost of the hiring of the facilities that are going to be used, don't have to have a court. All this, of course, means that you don't need the courts, you don't need the judges, you don't need the buildings that they're there, and it's going to be a cheaper way of running justice for the government. And the people will only pay for the time spent by the referee in hearing the matter. Ultimately, who pays that fee back or compensates the person who pays it is a matter for that referee to decide. But ultimately, it goes before this judicial referee who will come in and deal with how many hours it's thought necessary to do it, does all the investigations of the papers. He rings up anyone he needs to get evidence of. He satisfies himself by whatever means he considers necessary for him to decide what should be the result of that matter. And ultimately, he may overrule some of the rules of evidence. He may do whatever he thinks is proper to decide what he needs to decide. And at the end of the day, he makes a decision against which there's no right of appeal except on a question of law. There is no reason you have people sitting in the courts deciding for days, deciding on which side of the road the people were driving or whatever. It's a matter of fact. If you've got a building dispute, there is no reason that a person who's had experience in the building trade. I've got a friend of mine, he's an electrician, but he's now a fully qualified arbitrator and he deals with all sides of the industry disputes, and he is a far better person doing that than any judge, any lawyer dealing with that matter. So there will be specialist tribunals, there'll be building tribunals, there will be different tribunals, engineering tribunals, whatever area of expertise and specialisation that's necessary. And ultimately, lawyers will be becoming the determiners of the facts. They won't be necessarily in the case unless it's determined that lawyers are necessary, or if they are already in there, what roles they play. And up front, the person who looks at the case and to start off with will decide whether there's going to be any discovery or any of the all the litigation that goes on in the courts before people even get to the court, whether that'll be involved. So the system is provide a cheaper system of justice for people who seek to go to the courts to determine their disputes. It's simple. It should be good for the government. It should be good for the public. And I think it should be good for the legal profession because they are not doing very much for their images being involved as they do in these awful things. You put yourself in the position of a person who walks into the court and he walks in probably for the first time thinking about, oh, it's going to be heard today, I'm going to have my day in court, and he's got senior counsel, junior counsel, his own lawyer, and probably a clerk running around, and he looks across on the other side, same team on the other side, and he gets that feeling that somehow or other someone's going to be paying for all this today. They're not paying for the judge and the tip staff and the person at the side who's taking the evidence. That's all another expense borne by the government and the hire of the space they're in. But he's pretty formidable what he's going to be up for if he loses. And that is what sends people bankrupt. That's what prevents people getting access to justice. They can't afford the system that we've set up. We're all guilty. The judges are guilty. The system that they set up of management and everything else simply doesn't work. The people who want to extend cases and run things on and drive the other side mad, they can still do it. Doesn't matter how good the judges are or the managers are. So I'm saying to you, listen, we're ordinary people. I'm talking to you in ordinary language. We're talking about a system that's not working, and we've got to do something about it.
Thanks very much, John. I think you raised some really interesting ideas, and I think it's something we should seriously think about for access to justice in an affordable way. Are there any questions from the panel? Elizabeth.
Thank you, Pauline. John, I was quite interested, and you caught my attention when you refer to your observation in more recent years, and I think you say that you've been disgusted by unprofessional bullying tactics. I'm quite keen to hear what you say from an historical change perspective, as a driver of change. Is what we're hearing from you is that the legal profession changing? I'm not so much the system, but the lawyers themselves and their conduct. Can you elaborate on that as a change?
I can say that they have come to the fore, in my experience in recent years, people in the litigation side, commercial litigation, they get a name for themselves, right? And I think they bring more dishonour to justice, to the legal profession than anybody else. They're arrogant. Bullying is definitely the word that covers them, but their use of process as a means of trying to drive the other side out of existence. And I've been involved in it, my clients have been involved in it, and we're involved today in matters where those sort of lawyers are sitting on the other side, and you think, why should this be even allowed? Why should this happen? I was involved in one matter where I felt like picking up the whole lot of the matter and taking it into the Law Society, and I thought, well, that's not going to do any good. What are they going to do? Go back to the judge, go back to the court. But the actions of the parties were beyond what is acceptable from a person in the legal profession, someone that I regard as having the need for treatment as a bully, as a professional person with supposed ethics. I heard earlier Professor Greentree look for some system of funding outside the present system, and I think that it is very appropriate for the Law Society to look at an annual fee as part of the renewal of practicing certificates, that lawyers per head contribute so much to it to provide the service. So what he has done and his confreres have done to produce this wonderful system that we can use as easily as we can and improve on it by the year. I congratulate him and his team, and I would like to back him up in suggesting that's what the Law Society should look at.
Look, I completely agree that that work has been incredible, and it's been such a great gift to the legal community and the community of New South Wales. So.
And I might say to the Law Society, they're precedents. They shouldn't be selling them in the way they do. They should make them available to every legal practitioner to be able to level with other firms. And that's what they were giving it to them in the first place. And they should make those equally available and also include that fee in the same basis as the money for Austlii.
Well, thank you very much. We'll take that on board and with great interest, actually. Thank you. Thank you very much.
Thank you.